Hello and welcome to PPL 518 Alternative Dispute Resolution 2. I'm Francisca Anene and I will be the one taking you in this course. PPL 518 really, as I said, is Alternative Dispute Resolution, but we'll be focusing on arbitration. By now, you should have done 517, so you'd have looked at some of the other forms of alternative dispute resolution. In this first lesson, what we'll be looking at is a general introduction. So we'll be defining arbitration and then identifying particular features and helping ourselves to get to the point where we are not just tied to a particular definition, but we are able to define it in our own words. So let's go on to the lesson, and I hope you pay attention and get the most out of it. Let's go. So what you'll be learning in this particular lesson is that you'll be able to analyze various lesson definitions of arbitration. You'll be able to define arbitration in your own words, and you'll be able to differentiate between arbitration and litigation. What is arbitration? The first thing you must bear in mind is that there are very many definitions of arbitration. We can't take all of them in one lesson. But what we are doing is bringing out some definitions and analyzing them to help us to get to the point where we know the features we are looking for and are able to define it. So we'll be looking basically at various sources of the definitions from English law and then from Nigerian authorities purposes. What is an uncontrolled decision? Who is being controlled? Who is not being controlled? And when you begin to look at other definitions, you'll see that this definition is lacking if you're looking at it from the legal context. Hosbury's Laws of England. It says that arbitration is the process of dispute resolution where parties agree that they should refer their issue to be determined judicially and with binding effect by the application of law by a tribunal instead of a court of law. Now, you'll notice that I highlighted some points. Those are salient features of arbitration. A judicial decision, even though not necessarily by court, binding, the decision is binding, and usually they apply legal principles, basic principles of law and equity come to play in any arbitral issue that is being resolved. We must look again at another definition. Words and phrases legally defined says that arbitration is a reference of a dispute or difference between not less than two persons for definition. Again, it talks about hearing both sides, decision being made in a judicial manner by a party other than a court of competent jurisdiction. If you notice, Hosbury's Laws of England and words and phrases legally defined, even though they have gone beyond just a basic definition and have highlighted some features, do not necessarily answer that question that Oxford English Dictionary raised as to arbitration being uncontrolled decision, as to who controls arbitration. These definitions do not answer that. Okay, so now, as I said, Brown and Marriott is an authority, is the basic text in arbitration. It's like the Bible for arbitration. ADRO generally, and particularly because we're talking about arbitration, is a reference point for ADRO, particularly under English law. And they state it from the very beginning in their definition that their reference to this decision, their definition is with reference to English law. So other jurisdiction may have other definitions. That's fine. But as long as it applies to English law, this their definition becomes relevant. And you know, of course, that we have a lot to do with English law. That is why this definition is also relevant to us. So they say that it is a private mechanism for the resolution of disputes, which takes place in private, pursuant to an agreement between two or more parties, under which parties agree to be bound by the decision given by the arbitrator according to law after a fair hearing, such decision being enforceable at law. You'll see that definition in page 65 of the text. Now, apart from highlighting features that it is private, it takes place in private, um, it takes place pursuant to agreement between parties. Parties have to agree. There's fair hearing. It is enforceable in law. It also answers the question that the Oxford English Dictionary raised. the issue of control. If it is private, taking place in private, pursuant to agreement between parties, parties agreeing to be bound, and whatever decision being enforceable in law, then it means that it is not uncontrolled, as the dictionary said, but it is controlled by the parties in private. So you see that it just jettisons that problem of, looking at arbitration as unwieldy, and it properly locates it within a sphere of control. The control here being private as against public. Litigation is public. And we'll look at that when we look at the differences between arbitration and litigation. Let's look at what Nigerian authorities have also said about what arbitration means. In NNPC and Luton Investments, a 2006 decision of the Supreme Court basically adopted the Hosbury's Law's definition of arbitration. And you know, of course, that following the doctrine of precedent, every lower court will, follow the same principle as well. Now, Onoselugu and Afribank, a decision given by the Court of Appeal the previous year, was defining an arbitration agreement, but is relevant for this lesson because it also highlighted the features that we have been talking about. It talked about part two or more persons agreeing. It talks about the decision being legally binding. It talked about the arbitrator being impartial and examining issues in a judicial manner upon evidence put before him or them. Of course, there are some gaps in this definition, but as I said, the court was not defining arbitration, it was defining an arbitration agreement. So you can see, for instance, that it didn't start talking about it being enforceable and all of that, which is fine. Now, statute. The main Nigerian statute on arbitration is the Arbitration and Conciliation Act, and it does not contain any definition for arbitration. This is not unusual. Neither the same position applies for English law. The English Arbitration Act does not define arbitration, and that's because of the multiplicity of definitions. If they went ahead to define arbitration in a particular way, it means that they would exclude every other point that other definitions may raise, and you don't want that. So it's okay that no definition was advanced in the act, and of course you can see that courts have gone ahead to adopt other definitions, which solves the problem really. So we have been talking about definitions, and we have drawn out some features. First, arbitration is a private mechanism. It is only possible if parties agree to bring a dispute before arbitration. An arbitral award or arbitral decision is binding. In evaluating the issues, the arbitral tribunal is subject to the principles of natural justice. An arbitral award is also enforceable. So it's not just binding, it is enforceable. And it is quasi-judicial in nature, meaning that the arbitrator does not have to be a judge. The arbitrator may be an expert in a field that is not related to law, and because of the issues that are being looked at, he will be the best person to deal with the issue. Okay. To your first activity, we have talked about definitions. We have looked at various definitions. You remember them? We have looked at Brown and Marriott's Oxford Dictionary, Osbury's Laws, words and phrases. So what I need you to do now is think about all those definitions that we analyzed previously and tell me, or well, speak to yourself, and then you can always put your response in the discussion forum as well. Which do you prefer? Which of the definitions will you prefer, and why do you prefer that? So I'll just give you a few minutes to go over that, and then we can continue. Okay, having defined arbitration, let us now differentiate between arbitration and litigation. I've put two pictures in this slide for you to look at. The picture to your left is like an arbitral panel, arbitral sitting. The picture to your right, of course, is very clear from all the wigs and all that, is actually the Supreme Court. So the question is, how are these two different? Arbitration is private, we said that before. Litigation is public. Arbitration is selected and controlled by the parties. You remember I mentioned that when I was analyzing Brown and Marriott's definition vis-a-vis the Oxford definition. But litigation is controlled by the court. We have talked about it taking place in private. Now I need to highlight that for litigation taking place in public, it is a constitutional requirement. There are certain exceptions, but the truth of the matter is that a court case, people can always enter a courtroom subject to those exceptions, and then they will take part in proceedings. They will listen and all of that. And then arbitration is quasi judicial in nature. You remember we said that the arbitrator does not need to be a judge or a lawyer if what is being examined is not a legal issue. But for litigation, it is fully judicial. The person who must sit as judge must be someone with legal background, and he must be competent to sit as judge. So a magistrate cannot sit as judge over a matter that it doesn't have jurisdiction over. For instance, if you look at the Arbitration and Conciliation Act, it says that the court that has jurisdiction to look into issues regarding arbitration is the High Court. So you can't take such an issue to the magistrate court. So apart from it being judicial, it must also be competent. And then another difference is that the parties agree to submit to arbitration. There must be a meeting of minds. Parties must agree, okay, please, let's take this dispute out of the purview of the courts and let's deal with it under arbitration. But for litigation, parties do not need to agree. A party can go to court and, invite the other party, and whether the other party likes or not, he will have to come and defend himself. So those are the differences. There are many more differences, but for the purpose of this lesson, let those suffice for now. We will keep talking about them when we make reference in other lessons. And so this will bring us a question: which is preferable? Is arbitration preferable to litigation? Now, there's no right or wrong answer to this question. Some parties say it is preferable, others say it is not. When we make progress in the course, you will see, you know, benefits and burdens of each form of dispute resolution. But let's just look at two major authorities. Professor Schmidhoff, who is a highly regarded authority on arbitration, says that arbitration is better than litigation. He goes on to talk about conciliation and prevention of legal disputes and all that. But we are just drawing out the fact that he says that to him, arbitration is better than litigation. On the other hand, Fouchard, another highly regarded French authority on alternative dispute resolution, is of the impression that arbitration is rudimentary. And he says that because people who will sit as arbitrators may not be qualified lawyers. And then their only qualification is that they are chosen by the parties. Remember what we said about agreement between the parties. So as far as he's concerned, because of that, arbitration can never be better than litigation. So that brings us to the next activity. We'll look at that, but just before we look at this, our second and final activity. In this lesson, we have tried to look at a simple meaning of ADR. Remember, we said another form of another form of resolving disputes. We have looked at different definitions of arbitration. We have analyzed them and highlighted their features and identified some gaps in them. And then we have also talked about the differences between arbitration and litigation. Hopefully, you will now be able to think about it and come up with your own definition of arbitration. That's the whole point of this lesson, really, for you to get to the point where you can define arbitration confidently in your own words. Now, okay, we have come to the end of the lesson, and if you have any questions, feel free to post it on the discussion forum, and then we will see how we can answer it. And I'll encourage you, download the video, listen to it again and again, take part in the activities. They will help you. And so until we meet again for our lesson 2, I remain Francisca Anene and I wish you well. Take care.